The only thing I had was a current note, never late. What we found and have documented on our website, in my singular mortgage, we identified over 1,000 individually documented and legally cited events of either outright fraud or statute and code, state and federal violations of law.
Okay, now I want to go over the tax fraud issues, the security fraud issues, what's going on in the bankruptcy court. And as I pointed out in the introduction, this is the largest tax fraud case ever. It's the largest security fraud we've ever seen, and of course, the largest bankruptcy we've ever seen. And this ties into black operations, terrorist events, overthrows of government. We want to get into all that. That's the big picture, but let's take it a little bit at a time. Let's first go to the tax fraud issue. Explain the significance of the fact that you filed a RICO civil lawsuit in 3 states. Why did you do that for?
We filed it because we've had a federal civil pro se, meaning I represent myself, lawsuit filed initially in the Eastern District of Texas Federal District Court. What we have found since we've been at it for almost 3.5 years now, the case has promulgated into being in 3 different courts in 3 different states. And as of today, we still have not been allowed to have our first hearing of any kind. Wow. So what they've attempted to do clearly, and it's all on the docket, we can prove every single word we're saying with court-entered documents on the court dockets, is that they don't want the evidence, which now exceeds 15,000 pages. They don't want that evidence coming out. So what they've tried to do is to play the shuffle off the buffalo country boy kick the can routine with us by judges lying, lawyers lying, submitting fraudulent documents. Then we challenge them. They admit on the record that, yes, they did submit fraudulent documents. We're sorry. We didn't think you really wanted us to tell the truth. But now that you're motioning us for sanctions and motions to compel, now we'll give you the real truth. So they've been trying to keep me, in addition to the threats and all the rest of the malarkey that goes with it, they've been attempting to keep this case from coming out into the public. Not because of me. This is not about my case. This is about the fact that we have been able to take what we learned going down that rabbit hole, and we have been able to determine 3 things. 1, it is in fact the largest income tax evasion fraud in recorded history in this country. Second, it is the largest securities fraud in recorded history. And thirdly, a significant percentage, and until we were to under legal auspices or the joint congressional hearing that we're pressing for, got the hard drives of data from the other entities involved, David. I can't give you an exact percentage or dollar amount, but many of the dollars that were stolen from the American public through the mortgage crisis found their way through the Depository Trust and Clearing Corporation at 55 Water Street in Wall Street. They went from there to the Federal Reserve, then to the Union Bank of Switzerland, and many of those funds have been used to proffer terrorist activities and black ops.
And we got your website up there right now. Give us that website address.
It's that we have 2 of them. It's saveourfamilyandhome.com.
That's what we're seeing right now.
That's our evidence repository. And then redpillreports.com is our news marketing organization that communicates everything we're doing.
Now, one of the things I said in the introduction was this even touches on possibly on some of these banker suicides. We've seen a rash of banker suicides at a time when these guys are doing really well. It's not like it's the Depression where they're jumping out of windows, but a lot of people have died under mysterious circumstances. But I want to go to this, and that is Brad Birkenfeld. Now, he got $104 million from the IRS for exposing secretive banking operations and tax evasions involving UBS and the Swiss banking system. That all came about because of Brad Birkenfeld's whistleblowing. Yet, when he came to the Department of Justice with this information, nobody went to jail. Even after all this came to light, nobody went to jail except for the whistleblower himself, Brad Birkenfeld. That's where he met Scott Bennett in prison. Scott Bennett Was in the Army. He was with Booz Allen Hamilton, blew the whistle on some of the things that he discovered to his superiors. He was sent to jail, I believe, on some trumped up charges that look pretty phony.
They spent 6 months living together in this white collar jail up in Pennsylvania, in which they exchanged documents, stories, and dotted the I's and crossed the T's. And it appears, since Birkenfeld has not been available to us, it appears, and we have all the documented communiques to the military, to Congress, just as we do in my case on the whistleblower document, they are obviously running to hide. They do not want this coming out in any way, and they're doing everything they can to either not respond, or in my case, to Scott, or in my case, we've had 4 formal responses from 4 of the largest government agencies, which have in writing put their signatures on it to my attention. It's on the website for people to see, which says all of this stuff is outside our jurisdiction, including the Department of Justice.
Exactly. But of course, the Department of Justice was involved in the whistleblowers case. They sent him to jail for a couple of years. As he got out, he was handed a check for $104 million from the IRS for being a whistleblower. And as they had, after they had convicted him, the prosecutor, Kevin Downey, said that he needed the judge to give him some more time with the whistleblower because he was getting so much key intel from him. Don't take him away and send him to jail just yet. So admitted that it was very important. Now, one of the things that I want to pull out, which again hits possibly to these banker suicides, is how it looks like he was possibly set up, according to Scott Bennett. When Brad came from Switzerland to talk to the Department of Justice initially, shortly after that, one of his friends back in London, where he was living, got a communique from the Swiss bank, UBS, asking him why he had contacted them. They essentially had received a letter that was unsigned, that was in the name of this London friend who didn't know anything about this, because Brad Birkenfeld had done this secretively, had traveled there secretly to talk to the Department of Justice. Yet somebody who knew that he had talked to the Department of Justice had contacted UBS in the name of this friend who didn't know anything about it, presumably hoping that UBS would do something about it or do something to him, I presume. But yet they called this London friend, who was absolutely astonished, and then called Birkenfeld for an explanation. You want to comment on that?
Quite frankly, I'd rather let Scott at a later date go into all that detail, because he was much closer to the topic than I. What I can tell you is that if it looks like a duck, walks like a duck, quacks like a duck, let's don't shy away from making the ultimate conclusionary statement. That is, it's a duck.
Yeah.
These guys are covering this up because they know we're on their trail. They're afraid of it, and they don't know how to stop it, because we're in a position now where they cannot stop us from getting all the way to the Supreme Court and going to the Congress of the United States.
Greg, let's get down to some of the details of this tax evasion issue. And of course, at the heart of it is MERS. And we've talked to Dave Krieger about Clouded Title. He's the author of Clouded Title. We've talked about how they break the chain of title, how they evade taxes at the local county level. And of course, we all have to make up that tax revenue that the bankers don't pay when they break the chain of title and they securitize these instruments. But that's just the tip of the iceberg. That's the key to the tax evasion. And it gets down to something that I think a lot of people may not understand, and that is the REMICs that were created in the late 1980s, real estate mortgage investment conduit. Tell us a little bit about how that is at the core of the tax issue, the REMICs.
Okay, it's real simple, and I'm going to keep it very short. The procedure goes like this. You buy your house, it gets commingled into a trust, just an outright trust. Typically, of the thousands and thousands that were developed, they were, for the most part, all done under the trust laws of the state of New York, for obvious reasons, which we'll talk about. What would happen is that when those trusts were cleared out, meaning they said, we've got enough in this one trust, what would happen is they would typically file reports with the SEC for anywhere from 9 to 15 months. At the end of that period, they would file another SEC form, and I'm not even going to quote the forms because I don't want to confuse people with all the technical intricacy. But they would file a form, David. It is not a form that requires review, scrutiny, or approval by anybody at the IRS or the SEC. It's a simple filing. They file this form and they say two things, well, three things. One, we now have less than 300 owners of this trust.
Mhm.
Number two, therefore, we are going to opt out of paying federal income tax.
Yeah.
And third, we don't have to file any further quarterly reports with you. So we go into the ether, into the black, and you don't, at that point, know anything further about us.
Yeah, and let's point out that when they say they don't have to pay any tax, they made the argument that they were getting double taxation. Every corporation has and can make that argument. A lot of people have said we need to stop taxing corporations and businesses because that's just an invisible tax that's passed along to consumers, like a VAT tax. So fine, they're getting taxed double taxation, but the only people that get relief from double taxation are, of course, the bankers who have these employees in Washington called congressmen and senators. So they passed this RIMIC construct, which says, basically, as you just pointed out, they can make an assertion, file a piece of paper and say, we're no longer under your supervision, we don't have to pay taxes. But the key thing is that they have a clear, one of the key things, provisions of this RIMIC, is that they have to have a clear chain of title in these mortgages. Once they break that chain of title, now they are liable to taxes.
Now you're hitting it spot on. Here's the issue. There are two classifications of mortgages that surface in these trusts. One is called a qualifying mortgage, and the other one is a non-qualifying mortgage. Now, to be a qualified mortgage, there are a number of requirements. The first and most important of which is the fact that the chain of title is not broken.
And we don't really have to even go any further into the details of that because we've got a lot of stuff to cover. But that right there says that they are asserting that they don't have to pay taxes, but they themselves broke the chain of title, and now they are due to pay those taxes, but they're evading that. Now, I want to get to what happened when because you filed whistleblower status on the tax fraud. You filed with the SEC about security fraud, but I want to lay out the basis of both of those before we get the reaction of those. One thing I want to tell the audience, and I got this from the American Bar Association's website, talking about MERS. They say MERS is a separate corporation, of course, acting solely as nominee for the lender and lender successee. And on every one of these mortgages, they'll put down the quotation that MERS is now the mortgagee under the security instrument. However, they point out on the American Bar Association that MERS is not named on any of these notes. And they say, well, this is interesting because the legal status of the private recording system was not modified by Congress. And so they created their own rules, their own laws, their own organizations. It was the banks who created MERS. It was the banks who created DTCC that we're going to talk about here in just a moment. But then they point out this. They said this would cause RIMICs, what we're talking about, breaking the chain of title, this would cause those RIMICs to lose their preferred tax status. Surprisingly, the American Bar Association says, surprisingly, however, the IRS appears to be unresponsive to the issue so far. And this failure probably contributed to the financial crisis to some extent. You think so? What do you think, Greg?
I think that's a well-chosen set of politically correct terms all put together in complete sentences. It's baloney, it's malarkey, it's fraud on the American people, it's a lie.
Yeah.
They broke the chains of title as soon as that mortgage went into MERS. And we have all of the MERS internal control documents that other people do not have. Mm-hmm. Those documents show clearly that their intent was to, by design, separate the mortgage or the deed of trust from the note. Yeah. You can clearly prove that by going to the Fannie Mae, the government-sponsored enterprise that's bankrupt, that's now owned by the federal government, who owns, theoretically, your at least promissory note. As soon as you break the promissory note from the deed of trust under Carpenter v. Longan, they cannot be reattached without an act of the court with the compliance of the homeowner. That means once it's dead, it's dead. Mm-hmm. That means that when the chains of title are broken, they're no longer qualified to be in a trust. Then when they make the tax I want to call it tax avoidance election by being classified as a real estate mortgage investment conduit, they lose that tax exemption because the underlying mortgages no longer legally comply with the law.
That's right. Tax avoidance at that point becomes tax evasion. They're breaking the law. I want to move on quickly to the security fraud because I find it interesting that MERS, and for those of you who don't, that's the Mortgage Electronic Registration System, that was created in 1990.